as the first entity that's going to be taken into staff, there will be quite a few amendments to the bill that ERT has envisioned. So, Chair, the first one we're going to deal with is an amendment to the definition of regulator in the National Ports Act. So, Chair, the Ports Act had the regulator as the port regulator, established by Section 29. And I'm just going to put a caveat to members. I do hope that I have the correct updated and amendment bills, because we've worked with at least 3 of the bills I'm going to be cross-referencing today. So, Chair, the new regulator definition will be, the regulator means the transport economic regulator established by Section 29 of the Economic Regulation of Transport Act, which is this bill that we are working with. And then, Chair, the National Ports Act is hereby amended by repeal of sections 29 to 45, and the National Ports Act is hereby amended by the substitution of section 46 of the following subsection. Chair, I'm just going to take members to sections 29 to 45, or at least just the headings here quickly. So members will see here 29 to 45 are all these sections in the Ports Act that deals with the ports regulator. And then we get a new 46, which will deal with appeals. I just need to get to 46. Then, Chair, this is the old appeals section that we are proposing in the ERT bill. So that section will now be appeals. Any port user or licensed operator whose rights are adversely affected by a decision of the authority may appeal against that decision to the regulator in the manner directed under Section 30, subsection 3, or prescribed in terms of the Economic Regulation of Transport Act 2020. And then, Chair, there is a further, Chair, I'm just going to let the State Law Advisor and Parliamentary Legal Advisor come in here, where they indicated that we need some underlinings added, Chair, if that is fine with Chair, before I go to the amendments of Section 47.
Advocate. Am I seeing correctly that Ms. Haricharan, my attorney's hand is up? Am I correct?
Yes, that's correct, Chair. That's correct, Chair. Thank you. Chair, if we can draw to the committee's attention, on page 36 of the bill, that's Schedule 1, in line 18 of Schedule 1, the words that should be underlined start from the comma or prescribed in terms of the Economic Regulation of Transport Act, comma 2020. All of that should be underlined, and that will be included in the A list. Thank you, Chair.
Thank you very much. Advocate.
Chair, then going to Section 47 of the National Ports Act. So members will see here there is an amendment to subsections 1 and 2. 47 was complaints against the authority. So the new section 47 sub 1, any complaint against the authority must be lodged with the regulator in the manner directed under Section 30 sub 3 or prescribed in terms of the Economic Regulation of Transport Act. And then we have a subsection 2 amendment. A complaint against the authority may be based on any ground provided for by the regulator by direction under Section 30 sub 3 or prescribed in terms of the Economic Regulation of Transport Act, or on the ground that, and then the grounds will follow as it is, A, B, and C remains there. Then, Chair, there is a repeal of sections 48 to 45 proposed. That would be the investigation of complaint, hearings before the regulator. Just want to make it up to 55. The right to participate in hearings, taking of evidence at hearing, rules of procedure, interim relief, orders of regulator, and winding up and dissolution of regulator, because the ERT bill does make provision for those already, so we don't need them to remain in the National Ports Act. Then, Chair, a amendment here to section 56, subsection 2. 56 is on agreements in port operations and services. So there's an amendment here to sub 2. That proposed amendment, an agreement concluded in terms of this section must A, provide for the authority to monitor and annually review performance with regard to the operation of the terminal or facility and the provision of the relevant services in terms of a performance standard specified in the agreement, and B, be lodged with the regulator within 20 business days from the date of last signature to the agreement. And Chair, there's a proposed insertion of 2A. The performance reviews contemplated in subsection 2 small a must be lodged with the regulator within 20 business days of issue thereof. And then, Chair, there's a further addition proposed to section 56 of subsections 6 and 7. 6, the regulator may prescribe the requirements that are necessary to achieve the purposes set out in subsection 5. And 7, if an agreement contemplated in subsection 1 or 4 includes as a party an entity that is a subsidiary or division of an entity under whose ownership, management, or control the authority falls, the agreement must be approved by the regulator, or the regulator may require any variant to the agreement, depending on what the regulator considers necessary to meet the requirements of subsection 5, as well as a new 8. If the circumstances contemplated in subsection 7 apply, the fees payable to the authority in terms of section 73(1)(c) accrue to the regulator. Chair, then there's an amendment proposed to section 57 to add 6 capital A and 6 capital B. 57 deals with the license regarding port services and facilities. So here we'll have a new 7 capital A. A 6A, right there before 7. So Chair, 6A, if a license contemplated in subsection 2 is issued to an entity that is a subsidiary or a division of an entity under whose ownership, management, or control the authority falls, the license must be approved by the regulator, or regulator may require any variant to the license, depending on what the regulator considers necessary. Chair, then B, if the circumstances contemplated in sub 6A apply, the fees payable to the authority accrue to the regulator. Chair, then a proposed change to section 62. Section 62 is the duties of licensed operators. Chair, there is an addition of subsection 6. Every licensed operator, when submitting a report or other information to the authority in terms of subsection 2, 3, or 5A or F, must submit a copy of that report or information at the same time to the regulator. Then an amendment to section 72. Section 72 deals with the authority's tariff book. So, Chair, the authority must prepare proposed price control for approval by the regulator in terms of the Economic Regulation of Transport Act. So this sub C will also be removed, as well as the information there within the brackets. Chair, then the proposed amendment to section 79, sub 2. Chair, section 79 deals with the ministerial directions. (79) sub 2 is now proposed to be: the minister must consult with the authority, the transport economic regulator established by section 29 of the Economic Regulation of Transport Act, and the shareholding minister prior to giving a direction under subsection 1. Then there's a amendment proposed to section 80, and this is the last amendment to the National Ports Act. Section 8 deals with the port regulations. So 80 is then proposed to be: the minister may, in consultation with the regulator by notice in the Gazette, make regulations in respect of A, the licensing of activities carried out in the ports and at offshore cargo handling facilities, and B, the establishment, construction, maintenance, and operation of offshore cargo handling facilities. There's a new one, capital A: the minister may, by notice in the Gazette, make regulations in respect of any other matter which it is necessary or expedient to prescribe for the proper implementation or administration of this act. And Chair, there's a deletion proposed from subsection 2 of paragraphs E and P. Just to show members, E was the licensing of activities carried out in the ports and at offshore cargo, because it's already now there in the bill. And P is the establishment, construction, maintenance, and operation of offshore cargo handling facilities. So, Chair, those are the proposed amendments to the National Ports Act in Schedule 1. I think we can just get members' input there before I move on to the Airports Company Act amendments, Chair.
Thank you, Advocate. I can see the hand of Attorney Aricheren is up again. Am I correct, ma'am?
Yes, thank you, Chair. That's correct. Chair, I just have one comment regarding the proposed amendment to section 72 of the National Ports Act, just to indicate where the word should be underlining for the underlining to be included. On page 37, in line 30, from line 30 to 31, the words prepare a proposed price control for approval by the regulator in terms of the Economic Regulation of Transport Act, 2020, all should be underlined, Chair. Thank you, Chair.
Thank you very much, Mayor Richardson. As you lower your hand.
Thank you, Chair.
Thank you. Let me hear from members. Mkhayesu. Honorable Situla. Oh, not what do medis. Kiyawudla. Asithokoza mhlonishwa wamapena.
Sorry about that, Chairperson. Yes, look, I think I have no serious qualms with what has been suggested, so I think all is good.
Thank you very much. Honorable Member Baba Uchambaso Ulisa Wagwamango.
Chair, thank you. I see those young guys, I thought they were awake, but looks like they are still asleep. Guys, wake up, please. We are at work. Honorable Seihlolo. Chair, I support the acceptance of the consequential amendments to the National Ports Regulator. Thank you, Chair.
Thank you very much, Honorable Member. We will get a number of them to come to the party. Thank you very much.
I think maybe Mr. Siklolo went to the loo, so we must always make that provision.
I am happily making that provision, Honorable Mapena. Do communicate to him once he's out. Advocate, can we forge ahead?
Thank you, Chairperson. Our next amendments look at amendments to the Airports Company Act. So, Chair, the first one is a proposed substitution of the definition of committee. Just to show members, committee means regulating committee established by Section 11. So that will now change to committee means the Transport Economic Regulator established by Section 29 of the Economic Regulation of Transport Act 2020. Chair, then there's a proposed amendment to Section 5. Chair, Section 5 deals with the functions of the company, company being AXA. Chair, just these highlighted bits in my copy of this bill was some previous amendments that we did in the AXA amendment bill that was before the previous committee. So we'll see if any of these ones correlate with those. The proposed amendment in Section 5 here is to delete in subsection 2 paragraphs E and F. So in subsection 2, the bill seeks to delete these two, or at least E as it was then, and then F as it was changed in the AXA amendment bill, that Amendment Act that was finalized also just last year, Chair. Chair, then there is a amendment proposed to Section 12, subsection 1. So, Chair, that used to be economic regulation of the company, subsection 1. So the proposed amendment is to be: the company shall not levy any airport charge at any company airport except in accordance with a price control approved and published in terms of the Economic Regulation of Transport Act 2020. Chair, then the proposed amendment to Section 13, subsections 1 and 2. So there's Section 13 for members: sale or closure of aerodrome or curtailment of relevant activity. So the amendments: if the company has indicated in a business plan contemplated in Section 7 that it intends to close or sell any aerodrome mentioned in Section 6(1)(a), or to terminate or substantially curtail a relevant activity which was carried on by the department or any person on behalf of the department immediately prior to the transfer date at such aerodrome, the company shall at the same time as it submits such business plan to the shareholding minister in terms of Section 7, submit a copy thereof to the minister. Then subsection 2, the minister shall consider consider and evaluate the implications of the intended action of the company mentioned in subsection 1. And then, Chair, here just going to go to B, because it links up here with the minister, may request advice from the Transport Economic Regulator in terms of the Act regarding any action that the minister may take in terms of subsection 3 or 4. Then there's a proposed amendment to Section 14, subsection 1, or just before subsection 1. So to show members, Section 14, failure of company to comply with provisions. Chair, the previous AXA amendment bill proposed amendments to Section 1 as well. So this is now any person who feels aggrieved by the failure of the company to comply with any provision of section 5.2 or 12.1 may file a complaint with the Transport Economic Regulator in terms of section 16 of the Economic Regulations of Transport Act. And then there is a further amendment proposed in the Act to delete sections 5.2E and F. I just want to get section 5. We're going back. G52E and F. So it's those two that we've indicated earlier. Deleting 11. Eleven is the regulating committee. Deletion of 12.2. This clause under economic regulation. And 12.12. This clause, the company shall at all times comply with conditions mentioned in subsection 7, and then also deletion of 14.2 to 4. So that would be the deletion of 14.2 to 4. So gee, those are the proposed amendments to the Airports Company Act. I would just request if the department or the state law advisors can just indicate whether or not these proposed amendments were on the Airports Company Act prior to the latest amendment bill having been promulgated, Chair. And then for members to consider the other proposals as well.
Advocate, thank you very much. Mayor Richard, do you want to say something?
Thank you, Chair. I just wanted to mention with regards to the proposed consequential amendments on page 38 of the bill from line 9 to 11. The words that have to be underlined include except in accordance with the price control approved and published in terms of the Economic Regulation of Transport Act 2020. All of that to please be underlined. And another underlining that is to please be included is from line 28 to 31. The words may request, sorry, Chair, the words may request advice from the Transport Economic Regulator in terms of the Economic Regulation of Transport Act, 2020, regarding any action that the minister may take in terms of subsection 3 or 4. All those words to please be underlined, Chair. Thank you. And secondly, in reply to Advocate Nell's request regarding the amendments made to the Airports Company Act, if you may please reflect on that, Chair, and revert to the committee on that point. If you may please come back to the committee on that point. Thank you, Chair.
Thank you very much, Mayor Richard. Natemio Ketsi Kudo, do you want to say something, sir?
Good morning, Honorable Chair. I am definitely covered. Thank you so much.
Thank you very much. Advocate Almanel, you also want me to test if your members are happy.
Absolutely, Chairperson.
Thank you very much. I can see, let's test members. Ndate Yabo, are you happy, sir?
I'm very happy, Chair.
You are very happy.
Yeah.
I can see you that you are happy. Thank you very much.
Thank you, Chair.
Thank you. Any other member, happiness, honorable members? Thank you, Honorable Mapena. Any issue going once, twice? Advocate Almanel, can we please forge ahead?
Thank you, Chairperson. Then our next proposed amendments are to the Air Traffic and Navigation Services Company Act, the ATNS Act. Again, we will just have to get clarity on whether or not these proposed amendments took into consideration the ATNS Amendment Act that was processed 2019-2020. Chair, so again, we have the proposed substitution of the definition of committee. So the committee was the committee as defined in Section 1 of the AXA Act, Airports Company Act. And since we've already amended it at the top, we have to do it here as well. And that would now mean the Transport Economic Regulator established by Section 29 of the Economic Regulation of Transport Act. Chair, then we have a proposed amendment to Section 11, subsection 1. That was the economic regulation of the company. So, Chair, the proposed change is now that the company shall not levy an air traffic service charge except in accordance with a price control approved and published in terms of the Economic Regulation of Transport Act 2020. Then, Chair, an amendment to Section 12, subsections 1 and 2. So 12 was the sale or closure of air navigation infrastructure. So, Chair, the new proposed subsection 1, if the company has indicated in a business plan contemplated in Section 7 that it intends to close or sell any air navigation infrastructure mentioned in Section 6(1)(a), or to terminate or substantially curtail an air traffic service or air navigation service which was rendered by the state or any person on behalf of the state, immediately prior to the transfer date, the company shall, at the same time as it submits such business plan to the shareholding minister in terms of Section 7, submit a copy thereof to the minister. Subsection 2, the minister shall consider and evaluate the implications of the intended action of the company mentioned in subsection 1. Chair, I'm just going to go here to 2, and then again, the minister may request advice from the Transport Economic Regulator in terms of the Economic Regulation of Transport Act regarding any action that the minister may take in terms of subsection 3 or 4. Chair, then a proposed amendment to Section 13. That was the failure of company to comply with provisions. So, Chair, the subsection 1 will now read, any person who feels aggrieved by the failure of the company to comply with any provision of Section 5(2) or 11(1) may file a complaint with the Transport Economic Regulator in terms of Section 16 of the Economic Regulation of Transport Act. And then, Chair, this is just again reference. There is deletion going to be of 5(2)(e) and F. So just to show members here, 5(2)(e) and F are these two provisions. And then a deletion of 11(2) to 12. So, Chair, that'll be from number 2 at the top there to 12. and of section 13(2) to 4. That will be those provisions, Chair. Then, Chair, that is the proposed amendments to the ATNS Act, Chairperson.
Thank you, Advocate. Those are the proposals. Let me hear happiness from honorable members. Tate Chris Hunsinger.
Thank you, Chairperson. My eyes just followed a different line. The reference to the sections 3 and 4. Could you, with your indulgence, Chair, just repeat that portion and particularly the reference of 3 and 4 there?
Yes, I'm pleased.
It's subsection 3 and 4 in sub B, I think.
Advocate.
Right, go ahead.
I just need to, Chairperson will see is there's a number 3, and that's subsections 1 and 2. So I just want to get where we have, here we have subsection 2, yes, dealing with 3 or 4. I just wanted to be sure if this is what Honorable Mr. Hunsinger is referring to.
Yes, yes, indeed, that one.
Is everything okay?
No, we're still waiting, Chair. We're still waiting.
Oh, okay.
Oh.
So, Chair, that will be section 12, 3 and 4. Just want to make sure. Yes, we're looking at section 12's amendments here.
So it's agreed by the Minister, the concurrence of the shareholding Minister in economy. Thank you, Chair.
Are you happy, Honorable Member? Thank you very much. Any seconder? Can I go to Mayor Mtoma or Mama Ukumalo? Honorable Figile? Okay.
Chairperson, I'll second in the absence of anybody else. Chairperson.
Thank you very much, Honorable McDonald. Advocate Almanel, let us voortgaan.
Chair, I just want to check with the State Law Advisor if there's any lines here that we need to underline that have not been underlined.
Let me give the opportunity to the State Law Advisor, Mayor Richard.
Thank you, Chair. On page 39 of Schedule 1, from line to line 12, the underlining that should be included is from the word may request advice from the Transport Economic Regulator, comma, in terms of the Economic Regulation of Transport Act, comma, 2020, comma, regarding any action. Yes, those are the words to be underlined, please, Chair. Thank you, Chair.
Are you happy, Advocate Almanel?
Yes, Chair. It's just so that we are all on the same page when we get to make sure that all the amendments are in. Chair, then we see the amendment to the National Land Transport Act is a very short one-line amendment here. So that's section 21. They are proposing a deletion of subsection 1, paragraph C. 21(1)(c), oversee fares charged for public transport services throughout the country. Chair, this one is again linked to the National Public Transport Regulator, this one. So that is the only amendment proposed for the NLTA, Chair.
Thank you very much, Advocate. Let me visit the state law advisor before I go to members. Anything that you want highlighted?
Chair, with regards to subsection 4, line 19 on page 39, the words any person who feels aggrieved by the failure. Sorry, Chair, all these words are to be underlined, starting from any person who feels aggrieved by the failure. Then you move on to the to be underlined. You read further along the word any to be underlined. And continuing on line 19, the words file a complaint with the Transport Economic Regulator in terms of section 16 of the Economic Regulation of Transport Act, 2020, all of that to please be underlined, Chair. This will be included in the A-list. Thank you, Chair.
Thank you very much, ma'am. Ubaba Ulisa wakwaManci.
Thank you, Chairperson. If I could ask, with your indulgence, that advocate goes back to that proposed deletion of 1C in the Principal Act. Thank you very much. I wanted to check why the D from the department is not being proposed to be deleted also, because it would appear to me it relates to fees also, or fare structure, which I'm assuming would then become the function of the regulator. Thank you, Chairperson.
Baba. Advocate. Masombuk. Or Ndate Megets is good.
Yeah, thank you so much. I think probably it would be an oversight from the department. I think Honorable Mangu has raised a critical point for consideration, Chair.
You still owe us on these critical points. You remember your undertaking that they make it.
Correct, Chair. We still have that in our mind, and yeah, if you ask us to respond to those, we are ready to do so, Chair. But yeah, we have prepared some response for you. Thank you.
Okay, thank you very much. So you agree that we can delete that one too? That they make it.
Sorry, Chair, I may have lost the latter part of your comment. I heard that you were saying we agree.
D
Sorry,
can also be deleted.
Can I request that we reflect on it? But I think with the first observation now, it looks like it moves to that direction, but I would want to check it, Chair, because there's in the latter part of the sentence, there's it in terms of section 8, it may have some certain implication there, Chair. Can I check it and then come back on that one?
Thank you very much. We're happy with that. With that in mind, can we move, honorable members? Honorable McD.
Chairperson, we can move. I'm happy with that. Thank you, Chair, with those amendments.
Thank you very much. Mayor Hari Charan.
Thank you,
And
Chair.
Honorable
Thank you,
Ons-
Chair.
Yes,
Yes.
ma'am.
Thank you, Chair. Just regarding that subsection 5, we just echo the sentiment of the department chair to just reflect on that question from the honorable member and to revert to the committee on that. We would we'd appreciate that opportunity. Thank you, Chair.
Thank you very much. Honorable Unsinger.
Thank you, Chair. It might be worthwhile to look at Section 8, Chairperson. Indeed, it has implications on a wider spectrum. We even might sort it out by looking at Section 8 now, but it's your prerogative and decision, Chair.
Let's allow them an opportunity to reflect. Honorable member, Section 8 is definitely part of their reflection. You wanted to contribute something on Section 8? Honorable Unsinger.
Chairperson, it definitely reflects on the MINMEC structure and the wider implications as well. So I would cautiously advise that that section be removed because it has wider implications. As you can see, it's a whole scope of aspects that are involved. So yeah, I would let's allow the department to get back and we can move on. Thank you.
Happy Advocate Almanel.
Thank you, Chairperson. Then our next one that we will be looking at are the amendments to the Sunroll and National Roads Act. So, Chair, the first proposed amendment is to Section 27, subsection 3A. 27 deals with the levying of tolls by the agency. And 3A is the amount of toll that may be levied under subsection 1. Any rebate thereon and any increase or reduction thereof is determined by the minister on the recommendation of the agency. So the amendment here is that it is determined by the Transport Economic Regulator in terms of Part A of Chapter 3 of the Economic Regulation of Transport Act on the recommendation of the agency. Chair, then there's a proposed deletion in subsection 3 of paragraph C and D. So that will be these two, Chair. The notices in the gazettes. And then a deletion of subsection 4, which is the approval for the declaration of a toll road. If they are proposing the deletion of the entire 4, that will be 4A, B, C. Let me just double check here. Yes, it's the entire subsection 4. So it's A, B, C, as well as D being proposed for deletion. Okay. And that will also include that bit there. Chair, then our next proposed amendment is to section 28 by adding a subsection 5. 28 here deals with the operation of toll roads and levying of toll by authorized persons. There is no 5, so we are proposing the addition of 5. The Transport Economic Regulator, established by Section 29 of the Economic Regulation of Transport Act 2020, may require an agreement contemplated in subsection 1 to make provision for periodic review by the Transport Economic Regulator of the level of tolls charged in terms of the agreement. Chair, that is the proposed amendments to the South African National Road Agency Limited and National Roads Act for members to consider. And then for the State Law Advisor, just to indicate where, if there are any underlinings that were missed here as well, Chair.
Ms. Haricharan.
Thank you,
Let's-
Chairperson. Yes, thank you, Chairperson. 933, the words to be underlined include Transport Economic Regulator in terms of Part A of Chapter 3 of the Economic Regulation of Transport Act, 2020, yes, that's to be, all of that to be, please be underlined. Thank you, Chairperson.
Thank you very much. Obaba Ulisa Wakwa Mangu.
Mangat, if with your indulgence, advocate could just beam that proposed amendment, please, section 27, I think, so that I can talk directly to it. Thank you very much. The proposal is the removal of the determination by the minister. Now, it is my understanding, subject to correction by our legal minds who are here, that it is the purview of the minister to make regulations. It would appear to me that we are now saying that function goes to the regulator and not the minister. That, I think, is the one that has got implication on the whole deletion that goes there after that Advocate Nell was highlighting. So before even going there, my clarity is it not the responsibility and powers of the minister to issue regulation on issues such as the tolls and whatever case it might be? Thank you, Chairperson. That is my clarity-seeking question, which obviously, depending on the response, has got implications on everything else in that particular proposal. Thank you, Chair.
Thank you, Jambaze. Honorable Unsinger.
Thank you, Chair. I've got a different view, but I absolutely support Honorable Mandu's concern, and I would be interested in the department's response to that. Although I think we are moving to a regime where all of those determinations with regards to economic transport is then at arm's length and quasi-independent in this new structure. So I think it's part of the reform process, but it would be interesting to get the department's response on this, what the thinking was behind this. But other than that, I'm happy with this section. Thank you, Chair.
Thank you very much, Honorable Unsinger.
Thank you, Honorable Chair. I had thought you wouldn't ask me to respond, Chair, because Honorable Hamsinger has actually responded to the question raised by Honorable Mangu to say that we're moving towards an independent oversight of economic regulation, which is now consolidated under the Transport Economic Regulator, Chair. That's exactly the principle in which we are trying to implement here, Chair. But I think there's one point that is important that is raised by Honorable Mango, that's with regard to regulation. We might probably want to look at the wording, but the principle and the idea is to move all functions of economic regulation located in various entities to the economic regulator and ensure that oversight is provided from an independent point of view, Chair. So I think I'll also be guided as to how best to phrase it from the regulation point of view, Chair. I know I may be partly giving you an answer, but partly not answering you, Chair. So that's where I'm coming from. Thank you, Chair.
Yeah, no, I hear what you're saying. The amount of toll that may be levied under subsection 1, any rebate thereon, and any increase or reduction thereof is determined by the minister on the recommendation of the agents. That is Me Almanel putting it, determined by the minister. Transport economic regulator in terms of part A of chapter 3 of the Economic Regulations of Transport Act 2020 on the recommendation of the agency. And that case,
Chair?
I'm coming back to you here.
Yes,
You may
Chair.
need to clean up what needs to be cleaned up. I think Honorable Manu's view is that the regulator will not regulate him or herself. The minister will still be needed to play an oversight role. I think that's what he's raising. I hear it properly. Let me hear Honorable Hunsinger.
Indeed, there's a bit of a loop that I also now suspect. If the entity, the future economic transport regulator entity, if that resorts under the minister, and you know we've now consolidated everything under one act with a regulator, etc., in place. To what extent is it independent, and what role does the minister then overarchingly have in terms of interfering, or in a good or a bad way, in what is intended to be an independent consolidated regulator? The other point that I wanted to just note with you, Chairperson, is the underlining, which in a way has not been accurate. Underlining particular sections of a bill under development or an amendment has particular status, and it's read in a particular way, and it's understood in a particular way. And I'm referring to the fact that this was published and it was asked for public participation. Now, afterwards, we are suggesting and asking for sections to be underlined that should have been underlined, which in a way was a bit unfair to the public participation process. And I'm just noting this, and I'm basically just recording this and putting it on the record as such. Thank you, Chair.
Thank you very much, Honorable Manu.
Thank you very much, Chair. I think the debate sparked by my question is important. But I think if as I was specific to, I still wanted to enter into the further debate. But my question is simple: who has the authority to issue regulations? Or is it an entity of the state? Who has authority legally? Now we can thereafter discuss the arm's length and so forth, which I totally agree with my fellow colleague, Honorable Hunsinger. Hence our agreement earlier on the appointment of the board and so forth, that we were trying to address. Who has the legal authority to issue regulations, regardless of who's advising? That for me is my request, to have it more simplified, and then we can engage in a further discussion. Thank you, Chairperson.
Mayor Richard.
Thank you, Chair. If I may please respond to the Honorable Member Hansinger's comment regarding the underlinings that should have been included in the schedule. Chair, we do apologize, but there seems to have been a printing error with the printing of the proofs of the bill. That underlining should have been included in the bill. However, we shall include that in the A list, and it was just due to a printing error that occurred, but those underlinings shall be included in the A list, Chair. Thank you, Chair.
Thank you very much. Delegate.
Thank you, Honorable Chair. I'm not having authority to respond to the question of who has the authority to issue regulations. But with the work that we've done so far of this bill, we've seemingly given those powers to the minister, but I think the legal experts will answer correctly as to who has the authority for drafting regulations. And I know for a fact that industry experts and entities may recommend certain changes through regulations, but I wouldn't want to dwell much on that one. I think it will be answered by the legal expert. I just want to share one more point for consideration by the chair in discussing this matter, because I'm reflecting on the earlier questions that the principle is to move towards arm's length. And if you look at the sections or the content of the sections we're discussing on, it's price control or price determination. The general principle of the bill on price determination is that the nitty-gritties of how price control for a specific sector will be undertaken, will be embedded either in the codes of good practice or in the regulations themselves. What I'm simply trying to say, my argument would be there is some element of considering to basically include that section, Chair, and make sure that we amend it the way it has been proposed from the minister to the Transport Economic Regulator. But we then have to be consistent in terms of, one, who's the authority to draft regulations, and secondly, who has, what is the process to be followed in drafting regulations. If indeed this area of work would have to follow the same current process of being gazetted through regulations and all that stuff, we then have to flag it as such in the bill, Chair. And remember, again, we have a section in the bill itself that talks to the process to be undertaken when regulations are drafted, issued, and so forth. This could be one point of area that we could also lump it under that section, Chair. But the bigger issue that I'm raising here, Chair, which is the first price, it's indeed amend as suggested here, Chair, and then make sure that we are consistent in terms of who's the authority, which is what we have been preaching, to say the minister would draft regulations. Obviously, the portfolio committee has been requesting that we we make sure that there is a role played by the portfolio committee in drafting those regulations. But we also have to be consistent in terms of the process in which we follow in drafting those regulations and publicizing those regulations, Chair. So my answer somehow is twofold: move towards changing the authority of the minister being the oversight player with regard to price control, but all at the same time make sure that we are consistent in terms of who's the authority of issuing regulations, and the process in which we are undertaking are consistent, Chair. Thank you.
Advocate Almanel.
Chair, it really is a twofold gazetted publication system created in this bill. Chair, just in terms of section 4 that we have in the bill, if we look, that section 4 speaks to the general regulations, and it indicates which regulations are to be made by the minister. And the minister grants the exemptions. Again here, determinations done by the minister. So we have these aspects that are done by the minister. But the clause in the bill that is linked to this one that we were working on now, linked to the tolls, is chapter 3A on price regulation. And when it comes to price regulation in terms of the bill, Chair, it falls on the regulator, not the minister, to deal with the price regulations. So Chair, then obviously that amendment will be the regulator, and the regulator will sit with the agency, which is SANRAL, to look at their proposed tolls in terms of the price control aspect of it. So Chair, it's really more linked to this one here, sub 12, that deals with those amendments and price control aspects. When we link it now back to the amendments to the SANRAL Act. I just want to quickly go to that Schedule 1. You will see here, this proposed amendment links it back there to the Part A, Chapter 3. And in terms of this one, it is the regulator, it's not the minister that deals with these issues as it is in the bill now. So the drafters will just have to sit and make sure that this amendment also links up with the changes that the committee has proposed for that Part A, Chapter 3. That's all that I wanted to point out for this discussion here, Chair, before we get the final input and move to Schedule 2.
Okay, Honorable Unsinger.
Chairperson, thank you. I think there's a lot more cloud that needs to be cleaned up than what we realize. In the sections that we just did, there are 3 references of levels of consultation that is allowed, but the status of consultation and the outcome and the decision-making authority in terms of firm direction following the consultation is not clear, and it's not spelled out. So firstly, there's a level of consultation that can or may or should happen between the minister and the regulator, but then there's also the other level of consultation between the regulator and the particular entity, in this case SANRAL. But consultation is not given any supportive outcome as such, that consultation must happen, or that consultation may happen, and that if there's a deadlock, who then has the final authority, because similar to the biggest contract that had the biggest flaw, namely Brexit, where there was no exit clause, it's good to design a contract for a happy marriage, but what happens if the happiness ends? And that is what we should look at. So therefore, Chairperson, I would propose that the department looks at this in terms of alignment of current functioning, because certainly it should not be more complicated, it should be less complicated, because there's a whole value chain attached to each of these price control decisions. So therefore, it shouldn't take longer. I'm excited about this piece of legislation because it can also address a lot of red tape, which we currently have. So yes, a lot more should be done in terms of aligning it, but then we should also focus on describing what we mean with consultation, but what we also mean with may, because it may happen or it may not happen, and I'm not referring to my colleague's surname. So, Chairperson, real action must be spelled out in terms of process, procedure, and so that the system at the end of the day benefits the function and role, and not the other way around. Thank you, Chair.
Mayor Archeran and Honorable Mang will be the last.
Thank you, Chair. Regarding the honorable members' queries raised regarding these items of the schedule, that we may also be afforded the opportunity to come back to the committee on these matters. And we have flagged this, Chair, and we will revert to the committee on this at a later stage. Thank you, Chair.
Thank you, Honorable Manu.
My chair, I'm close to calling you advocate now, but not yet there. Chair, if we could answer my question, I think many things that we are raising will begin either to be resolved or we will complicate them further. My question is, who has the legal authority to issue regulations? If that question is answered, all things of dual purpose that Advocate Nell highlighted now will then come to the fore. The issues that my colleague, Honorable Hunsinga, is raising will also certainly come to the fore. Then we'll have to apply our minds. But I don't want us to apply our minds against the grain of either the legal principles or the Constitution, whoever is responsible for that. Hence my question, and I said I've got further comments, but I needed to get that clarity as to who has the legal authority to issue regulations. Advocate, Honorable Chair, I rest my case.
Honorable Manu, I can see you have gone through this thoroughly. Advocate Almanel.
Chair, I believe as the department has indicated, the regulations, the principal authority is with the minister. There are instances where it will differ, as we've indicated, as the department has indicated previously in the bill, when it comes to considering the price regulations and changes thereto. But even, I think it might assist if the department gets back to members exactly on how they propose this to be done in the Act. As I've indicated, there's two different areas in this very bill that allows the minister to regulate as general, and then it allows the regulator to issue notices and regulations in the Gazette. Now, bringing in the toll issues, just to take members here, the tolls would have always been, there would have been a proposal by Sunroll. Yeah, like they would recommend it to the minister. And the minister would be the one then that issues the notice. You see, this again is the exemptions and amendments was given, will become effective only 14 days after notice to that effect by the agency. So if I just go up to the top, this is determination of a toll is done by the minister, and amendments thereto is also done by the minister. So it should follow that this be done by the minister. But Chair, I think the department, especially for how they envisage how the Starball will work, they might just need to clarify whether all of the proposed publications in the gazettes are regarded as regulations for the strictest sense of the application, not specific to fares and fees. But they will have to clarify that. Again, we have the other addition when it comes to finance bills, where they also need the inclusion of the Minister of Finance, which is another layer as well to it, Chair. So I think affording the department some time just to revert and clarify the issue to members fully might be the best solution, Chair.
Advocate, my clarity seeking question actually was not going to go to that direction. I was just trying to refresh my mind. What is the purpose of these deliberations?
Chair, for this, we need to get members' input on the proposed amendments. We will still have a clause by clause later on. So these deliberations will allow any further clarity that the members may need, that the department and the state law advisor and the parliamentary legal advisor can supply to members, so that we can draft a proposed A-list. Then when we have these issues and all of these aspects addressed, if it's not in the current bill, the A-list will seek to supplement the bill. And that is where we then get the final look at the bill under the A-list and clause by clause consideration. Chair, so these deliberations do allow the members in the committee time to get further input and clarity from the department to be sure what has to go into the A-list, or if the bill as it is suitable for members.
I'm saying where members want to make an input or suggestion, they are allowed, Advocate.
Yes, Chair, absolutely.
Okay. Okay. I thought I just wanted to get that point clearly clarified, and I want to believe that at this moment in time, we are all happy to say the department should go back and just make some cleanups in terms of the direction they are proposing here in terms of powers. Just clean this document up so that we are clear where we are going without really usurping anybody's power where it is not necessary, but also create a conducive environment for the agents and the regulator. I think that is clear, unless I need to clarify myself. Are we getting it clear, officials of the department?
Crystal clear, Honorable Chair.
Thank you very much. Honorable members, are we happy with that?
content, not happy, Chair.
Well, Jambas.
Your summary is okay, Chair. Let's leave it there. Thank you, Chair.
Thank you very much. Well, Advocate, can we forge ahead?
Yes, Chairperson, our next section that we are with at the bill will be Schedule 2, which is the transitional provisions. So Chair, the first one under the definitions, I reference in the schedule.
It should not be taken that these are people from the Free State.
Okay, Chair, I'll continue. A reference in the schedule to the ports regulator is a reference to the entity established under that name in terms of Chapter 5 of the National Ports Act. A section by number is a reference to the corresponding section of this act, and an item or a sub-item by number is a reference to the corresponding item or sub-item of this schedule. So Chair, that is in terms of the definitions, a transitional provision. Just want to check if members are okay to continue to the next one, Chair.
Chair, through you, yes, we can continue.
Okay, Chair, then I'll continue to the next item under Schedule 2 is the continuation of tariffs in force at effective date. So Chair, 2.1, despite Section 11.
Advocate, please, apology. Chair, can you indulge me half a second, please? Chair? My chairperson? Yamadot. Hey.
Yes, seemingly disappeared.
I told her when man, you are not chairperson. Hey, what do I do now? Do I ask what I want to ask without the permission? Maybe I'll come back, advocate. Let me not accept powers of the chair. Sorry for that.
That is wise, colleague. That is wise.
Thank you, members. Then to carry on with the continuation of tariffs, despite Section 11, a tariff or similar method of price regulation in effect immediately before the effective date in terms of any law in respect of a transport facility or service remains in effect as if it has been a price control determination and published in terms of Section 11 until the date on which the regulator first determines and publishes a new price control applicable to that facility or service subject to sub-item 2, and B, an agreement of the type contemplated in Section 11(9)(c) that was in effect immediately before the effective date remains in effect as if it had been approved in terms of this Act until the date on which the regulator first determines and publishes a new price control applicable to the relevant facility or service. 2.2, a pre-existing tariff or similar method of price regulation that remains in effect in terms of sub-item 1 may be reviewed in the manner provided for in Section 11. And 3, despite sub-items 1 and 2, a tariff or similar method of price regulation and review mechanisms in effect immediately before the effective date in terms of A, an agreement contemplated in Section 1 of the South African National Roads Agency Limited and National Roads Act, or B, an agreement or a license contemplated in Sections 56 and 57 respectively of the National Ports Act, that was concluded before the effective date remain in effect for the remaining period of that agreement or license, as the case may be. So, Chair, that is the first two items under Schedule 2 for members' input.
Thank you very much, Advocate. Baba Umang.
Chair, thank you very much. I'd interrupted rudely in your absence, and I apologize to Advocate when she was presenting, because I realized that I wanted to raise something earlier that I didn't raise because of the previous question. But the question is the following. And the reason I thought about it, I think it's got an implication on the tariffs we are discussing now. And the question is, Chair, I did not see any amendment proposed or consequential amendments to the cross-border road traffic Amendment Act, or rather Act, not Amendment Act. I heard about the NLTA. I don't know if I missed it, or is it covered somewhere? Thank you very much, Chair. That was my earlier question. Then if I'm answered, it would determine whether I've got an input on the tariffs as presented here by the Advocate. Thank you, Chair.
And now, apology well accepted, Honorable Mang. Advocate.
Chair, I think the department can best answer here. I would believe that those amendments to the CBRTA Act might come in later ones, or just prior to the phase 3 approach.
And that is Sikudo.
Thank you, Chair, and thanks for the question. If you put scrutiny to the bill in totality, it mainly focuses on phase 1, which was presented in the different sessions on the phases that we have in terms of the consolidation of economic regulators into one. And the phase 1 in the main, in terms of institutions, is to consolidate or start the transport economic regulator by using the ports regulator as a nucleus. And the second part of the stage 1 basically is to incorporate the regulating committee chair. And from the economic regulation perspective, primarily the bill focuses on tariff determination. So those were the principles which guided the bill that we have in front of you, Chair, today. Indeed, what Advocate Nell has indicated to say some of the incorporation and phasing in of other regulators will be done at a later stage, Chair. Yeah, that's my response. I'll end there. Thank you, Chair.
Honorable Manu.
Chair, I hear, but the response is not satisfactory. One of the examples that were made by Ndadesi Kudu and the team for many times was always a CBRTA as an example and so forth. But be it as it may, therefore, how does the NLTA come in? Because the NLTA, in my view, is much closer to the CBRTA. The ports regulator, I think it's very clear. It was mentioned that because there is already a regulator, no qualms about it. But I still don't understand the rationale of not picking up the amendments that would be effective, or rather what's the right English now? The amendments in terms of the implication of this regulator or legislation to the CBRTA Act. I don't buy that. Hear him, but so many other pieces of legislation here, and none of them, as far as I know, for instance, Sandral doesn't have a regulator currently, fees or tariff like the ports regulator. And yet when we deal with CBRTA, I believe that there are tariffs also stroke fees that are affected there. So without laboring on the issue, I suspect it was an oversight on the department, or else I'm totally missing the whole intention of what we are doing now. Thank you very much, Chairperson.
Thank you, Honorable Manu. Nademegit.
Honorable Chair. Honorable Chair, I would want to honestly and fairly indicate that it was never an oversight from the department to exclude certain areas. It is a well thought through process with the anticipation that on effective date, we would want to focus on certain areas, one of which relates to determination of prices of the areas that we have selected, which include the Sandral part of it, because the focus on that Sandral part of it is the oversight of economic regulation, specifically related to the tariff determination. With respect to the National Transport Act, if you look at the functions of the regulator that we have ignored, but focused on, is the one that relates to tariff determination. Chair, because the scope in which we then said, which I repeat, on effective date, the regulator should ring-fence its resources, its experience, its attitude towards making sure that price determination matters are well-functioning, are well-oiled and functioned quite well. We then said, what then would be the supporting institutions to build up the end goal of having a single transport economic regulator? It was then, we have resources currently, which is the ports regulator that is functioning quite well, and we can build up from it. What would be the other regulator that we will consider? Then we then made a decision to say, in the aviation space, a focus committee or institutional arrangement that focuses on economic regulation of tariff determination is the regulating committee, which functions well to provide oversight for ATNS as well as AXA Chair. And then we then said, what would be the third layer, which we could capacitate the institution that we're working on and not disturb the whole transport sector system. Then we then said, let's introduce a new economic regulation framework and oversight for the rail sector. That part of economic regulation, Chair, will take much of time, much of resources from the economic regulator that we are set up in. So that's the phase one in which we're focusing this bill on, so that you have this institution function quite well before then incorporating other areas. CBRTA, it's a big institution, we agree, but you don't want to take on that institution at the beginning when the single transport economic regulator institution is still fairly new. It's still trying to understand, to consolidate other areas that have been identified at an earlier place. But the Cross-Border Road Transport Agency, including the National Public Transport Regulator, including the Licensing Council Chair, would then be incorporated. Probably the question we should be asking, which I would be asking now, is the way the bill is structured, particularly from the transition mechanism point of view, is it fit enough when it is made effective to allow for other economic regulators to be incorporated at a later stage, instead of having to go through an amendment process when the bill is acted, and because it will take time and all the stuff. I am not in a good position to answer on that one. But when we looked at this issue, we were advised and properly advised to say the focus of the bill should be on phase one, and the other areas will be looked at a later stage, Chair. So, but yeah, it is never an oversight from the department, hence the presentations and the slides around the phases and supported by the bill the way it is shaped and formed, Chair. Thank you so much.
With that, honorable members, as hot as this debate is getting, please allow me to cool this debate down by requesting you that we shall continue on this matter on Friday. According to our commitment earlier on, we said from 12:46 onwards, we shall be dealing with minutes. I will definitely afford members an opportunity to finish the work we have not finished. So thank you very much for understanding. Can we then please deal with minutes that we were not able to deal with? The minutes of the 17th of February is the first set of minutes. Can I have a mover or anybody who wants to correct something on the minutes?
In order, Chair.
Thank you very much, Mkhayesu. Any seconder?
Seconded.
Thank you very much. But any matters arising from the minutes?
Chair, just one issue quickly. I just want to know if Mr. Hunsinger or Mr. Mabena is in the meeting for the minutes adoption. Because Mr. Sitlole is an alternate member, unfortunately, for decision making.
Well, yeah, Chair, we'll. Yeah.
Honorable Mabena had already indicated his support. Thank you very much. I saw your hand.
Thank you.
Very much. Minutes of the 19th of February. Any mover? Boramadwa. Do we have Honorable Ramadwa here? Or she's still traveling? Let's get Honorable Figile. Honorable Yabo, minutes of the 19th.
Honorable Chair, excuse my silence. I'm on my way to the parliamentary precinct. I'm getting on the bus, but yes, I second.
Thank you very much. Any matters arising from the minutes of the 19th?
Do I have to fill it?
Nothing. Can we now deal with the minutes of the 23rd February? McD?
Apologies, Chair. I lost signal there, but I'm in support, Chair. I move.
Move. Thank you very much.
Okay, my apologies again. I just want to bring you back to the minutes of the 19th. Mr. Yabo seconded, but I did not catch who actually moved for the adoption.
Okay. Back to the minutes of the 19th.
I will move, Chair.
Thank you. Any seconder, honorable members? We start all over again.
I'll second Chairperson Honorable MacDonald.
Thank you very much. And you had already moved for the minutes of the 23rd, am I correct?
You are 100% correct. You're never wrong, Chairperson.
Thank you very much. Any seconder?
I second the minutes, Chair.
Thank you very much. Any matters arising, honorable members? Thank you very much. The last set of minutes, that will be the minutes of the 24th February 2021. Any mover? Mhlonishwa Masithokoze Babu Mapeni.
It's fine, I'll move, Chair, because you are coercing me to move. I'll move.
Thank you very much. Any seconder?
I'm not coerced, Chair, but if coercing works, let us continue doing it. I do second.
Thank you very much. Any matters arising? Thank you very much, honorable members. At this stage, I wish to say we should create time, whether on the Zoom, which I think will be proper, to give feedback in terms of the Moloto corridor and as we had promised the people of Bomhlanga. Otherwise, they will be phoning now and then, requesting when are we coming back and so forth. I think let's put that on the agenda and just spend 2-3 minutes as we meet together tomorrow. Otherwise, thank you very much, honorable members. Thank you very much for your commitment. Let's have it. Okay.
Apologies. I think as we put the Moloto corridor on the agenda, we see that CEOs are being unveiled on Twitter. And I think you had seriously discouraged that behavior by the department. I think Honorable MacDonald is on record. Honorable Ketamawala Stole is on record. And I think yourself as well, but you were much more reserved. You wanted to resolve the issue amicably. You indicated that you met with the minister. You've spoken about issues, you've ironed out loose ends. However, the behavior is continuing. Like a whole CEO was unveiled on Twitter, and like it's just a mess. There's no, like it's just, things are just happening. The portfolio committee is still in the dark. And unfortunately for some of the older members who are not on Twitter, you wouldn't have had the privilege of seeing the CEO being unveiled. So, Chair, I think perhaps in your follow-up meeting with the minister, maybe you must drink coffee, but don't add sugar on your coffee. Just drink it black. And then maybe that would encourage you to, to nip some of these things in the bud. I think I'm just depositing that as we put the 3 minutes for Moloto.
Order, Chairperson. This member is out of order. Out of order, Chair.
Chairperson, that member is not out of order. He's on the point. You still remember last time I asked the question about this Moloto Road, and then you said you have solved it. You never
Honorable Chabagu is out of order. The meeting is still in the chair's hand. Can we allow the chairperson to chair the meeting, please?
Yeah, he's chairing, and you must also not chair the meeting.
Honorable members, I hear what the Honorable Mapena is saying, and I think we need to deal with it. Allow me to deal with that matter. I will raise the matter tomorrow, Honorable Mapena. I can give you my undertaking that we'll deal with that matter amicably. It's quite a matter. Thank you very much. We will then deal with Muloto tomorrow and finalize how do we deal with it. Otherwise, with the spirit that always prevail in this August House, allow me to adjourn this meeting and say long live all
The chair.
Thank you very much.
Long live
Long
the
live
chair.
the
Long
chair.
live.
Long live the
We must
chair.
stop trying to
Mangete.
behave like Honorable
Man,
Kate.
we must meet somewhere together with you. You're out
Long
of
live the
want to
chair.
speak
Long
the
live.
stage.
There are so many chairs. Which one must live long? Which one? Which one?
Even
live
you,
the
comrade.
chair. Long
Even
live.
you, comrade.
Man,
Even
man,
you,
you must
comrade
live long
Ansiman.
because it's the new chairperson. You are the new chairperson. Well.
Long live the chair. Long live.
This committee is under capture.